He was already smiling before he sat down. Not because the courtroom felt friendly, it didn't, but because everything about this morning confirmed what he already knew. The wood-paneled walls, the bored clerks, the quiet shuffle of paperwork. This was a formality, not a battle. A clean ending to a messy marriage, and he had written the ending months ago. Then she walked in. Alone. No attorney at her side, no briefcase, no whispered strategy session in the aisle. Just her, a simple folder in her hands, dressed plainly, hair pulled back, eyes forward. For half a second, his smile sharpened into something close to amusement. He leaned back in his chair, crossed his arms, and let out a slow breath through his nose. Of course she came alone. That was exactly how he'd imagined it, exactly how it was supposed to happen. He glanced sideways at his lawyer, who followed his gaze and gave a subtle nod. The kind professionals use when the outcome is already decided. The kind that says, "Don't worry, this will be quick." He watched her walk to the opposite table and sit down. She didn't look at him, not once. No nervous scanning of the room, no searching for reassurance. She simply placed the folder on the table and folded her hands on top of it. Posture straight, expression unreadable. He mistook that for defeat. He remembered the last time they'd sat across from each other like this. The kitchen table, late at night, bank statements spread out. Her voice shaking as she asked questions she didn't yet know how to ask. That night, he had stayed calm, explained numbers slowly, smiled gently, told her she wouldn't understand the details anyway, that stress wasn't good for her. She had believed him then, or at least she had gone quiet. Silence had always meant surrender with her. The bailiff called the case. Everyone stood. The judge entered, took his seat, adjusted his glasses. Routine. Predictable. Safe. He stood confidently, jacket buttoned, chin slightly raised. He'd chosen this suit carefully, neutral, respectable, successful. The kind of man judges trusted. When they sat again, he allowed himself another glance at her. Still calm, still alone, still not looking at him. She didn't even bother to fight, he thought, after everything. His lawyer leaned in, whispering that they'd proceed as discussed. Minimal complications, asset division already outlined. The judge would appreciate efficiency. He nodded once, barely listening. His attention stayed on her, on the absence beside her chair. No lawyer meant no strategy. No strategy meant no resistance. And no resistance meant he would walk out of this courtroom exactly as he'd planned, with the house, the accounts, the narrative. She'd get what was fair, which, in his mind, meant what he allowed. The judge looked down at the file, flipping a page. "Let's begin," he said. His lawyer stood first. As the opening statement started, he relaxed even further. This was familiar territory. Words like equitable, reasonable, documented. Clean language that hid sharp edges underneath. Dates were cited, figures mentioned. He watched the judge nod along, pen moving steadily across the page. Across the room, his wife listened without reaction. No objections, no notes, no visible confusion. It almost annoyed him. He'd expected tears, or at least tension, some sign that this was hard for her. Instead, she sat perfectly still, eyes on the judge, breathing even. When his lawyer finished and sat back down, he caught himself feeling something close to disappointment. Then the judge turned his gaze toward her. "Mrs. Carter," he said calmly, "you're representing yourself today." "Yes, Your Honor." Her voice was steady, clear, not soft, not apologetic. Something flickered in his chest, a brief, irrational irritation, but he pushed it aside. People rehearsed confidence when they had nothing else left. He'd seen it before. The judge nodded once. "Very well. You may speak when ready." She stood. Not rushed, not hesitant. She picked up the folder, opened it, and for the first time since entering the room, lifted her eyes. Not to him, to the judge. And as she began to speak, measured and precise, he realized, too late, that this wasn't the sound of a woman giving up. It was the sound of someone who had prepared. He didn't listen to her words at first. Not really. He watched her instead. The way she stood without shifting her weight. The way her hands didn't tremble as she held the folder. The way her voice carried without forcing itself. It irritated him how composed she sounded. Composure had never been her strength. Not when they argued. Not when money came up. Not when she felt cornered. This was new. She wasn't telling a story. She wasn't defending herself. She was laying out facts, dates, actions, sequences. Each sentence landed cleanly and ended without trailing emotion. She spoke as if the outcome didn't depend on persuasion, only accuracy. He leaned back again, forcing calm. Anyone can read prepared lines, he told himself. That doesn't mean anything. The judge listened without interrupting. That was unusual. Normally, judges cut people off, especially self-represented spouses. They guided them, redirected them, kept things moving. But this time, the judge let her speak, page after page. Occasionally, he glanced down at the file in front of him, then back up at her, then made a small note. Across the aisle, his lawyer's pen slowed. That caught his attention. He leaned slightly toward him, whispering, "What is she doing?" His lawyer didn't answer right away. He was watching her now too, head tilted, brow faintly creased. "She's organized," he murmured back. "Unusually so." The word bothered him more than it should have. Organized meant preparation. Preparation meant time, and time meant intention. She reached the end of her initial statement and closed the folder, resting it lightly against the table. "That's all for now, Your Honor," she said. "For now." The judge nodded. "Thank you, Mrs. Carter." He turned his attention back to the case file. "I have a few questions." The questions weren't directed at her, they were directed at him. "Mr. Carter," the judge said, lifting his eyes, "your counsel submitted financial disclosures dated 6 months ago, is that correct?" "Yes, that was the most recent complete accounting." The judge nodded slowly. "And since then, there have been no material changes to assets, income streams, or holdings." He hesitated for half a second too long. "No material changes," he said. "Nothing that would affect the division." The judge made another note. "Mrs. Carter," the judge said, without looking up, "you mentioned additional documentation. Do you have it with you?" "Yes, Your Honor." She opened the folder again, not hurried, not dramatic, and removed a thin stack of papers, neatly clipped. She approached the clerk, handed them over, and returned to her seat without once glancing in his direction. The clerk passed the documents to the judge. He watched the judge's expression shift, not sharply, just enough. A tightening around the eyes, a pause that stretched longer than comfort allowed. His lawyer leaned forward now, tension replacing confidence. "Your Honor," he began, "if I may, we haven't had the opportunity to review." "You will," the judge said, calmly, holding up a hand, "in due time." That was when the first crack formed. It wasn't panic yet. Panic was loud. This was quieter, colder. The sudden awareness that the room had stopped moving according to his expectations. The judge flipped a page, then another. "Mrs. Carter," he said, without looking up, "these records appear to show account activity not reflected in the original disclosures." "Yes, Your Honor." "And these accounts are held solely in Mr. Carter's name." "Yes." He felt his jaw tighten. Those accounts were old, clean, buried beneath layers of structure and explanation. She wasn't supposed to know about them. She couldn't have known, not without help, not without access she never had. Unless she hadn't been as isolated as he thought. His lawyer whispered urgently now, "Where did she get this?" He didn't answer. He couldn't. Across the room, she stood again when the judge addressed her, posture unchanged, voice still steady. No triumph, no edge, just certainty. He finally looked at her then. She met his eyes for the first time that day. There was no anger there, no satisfaction, just focus. And in that moment, something settled in his stomach, heavy and undeniable. This wasn't a mistake. This wasn't luck. This had been planned. The air in the courtroom had changed, though no one said it out loud. He felt it in the way the judge leaned back slightly, no longer skimming, but reading. In the way his lawyer stopped whispering and started watching. In the way the clerk's fingers hovered over the keyboard, waiting. This wasn't procedural anymore. The judge adjusted the stack of papers she had submitted. Mr. Carter, he said, calmly but firmly, can you explain why these accounts were omitted from your disclosure? He cleared his throat. Those aren't active income accounts, he replied. They're legacy holdings, long term. I didn't believe they were relevant. The judge looked up. They show regular movement. Transfers, he said quickly. Internal. The judge paused. Transfers to where? His lawyer stood. Your Honor, if I may, the judge raised a hand again. I asked Mr. Carter. He felt the floor tilt, just slightly. To investment vehicles, he said. All documented, all legal. Silence followed. Not the awkward kind, the deliberate kind. The judge turned a page. Mrs. Carter, you've marked several transactions here. Can you clarify? Yes, Your Honor. She stood again. Those transfers coincide with the months I was told there was no extra money available. During those same periods, joint household accounts showed reduced balances, while these accounts received deposits. He stared at her. She wasn't accusing, she was correlating. That's interpretation, his lawyer interjected. Correlation doesn't imply intent. Agreed, the judge said, which is why intent must be examined alongside pattern. He felt heat crawl up his neck. The judge continued. Mrs. Carter, how did you obtain these records? She didn't hesitate. Through subpoenaed statements from institutions listed in prior tax filings, Your Honor. Subpoenaed. He shot a look at his lawyer. His lawyer didn't meet his eyes. You didn't tell me she had that authority, he hissed under his breath. She shouldn't have, his lawyer muttered back, unless the court granted. The court did, as if reading their thoughts, based on a preliminary motion filed by Mrs. Carter 3 months ago. 3 months. That was before mediation, before the final filings, before he thought any of this mattered. He tried to rewind time in his head, searching for the moment he'd missed. There had been emails he ignored, notices he skimmed, a calm voice across the kitchen table telling him she was handling some paperwork. He laughed then. Now the judge was speaking again. Mr. Carter, do you dispute the accuracy of these documents? He opened his mouth, closed it, opened it again. No, but do you dispute the existence of these accounts? No. Do you dispute that they were omitted from your disclosures? His lawyer shifted beside him. Yes, no, but not intentionally. The judge made another note. Mrs. Carter sat down, hands folded again, eyes forward. She hadn't looked at him since that first glance. She didn't need to. The judge leaned forward now. Intents will be evaluated, but omission itself is not neutral. He paused. This court takes financial transparency seriously. For the first time that morning, his confidence cracked audibly. This is getting blown out of proportion, he said, louder than he meant to. We're talking about technicalities. The judge's gaze hardened. We are talking about trust. That word landed heavier than any accusation. He sank back into his chair, heart beating faster than it should. This wasn't how it was supposed to go. She wasn't supposed to have leverage. She wasn't supposed to know where to push. Across the room, she remained still, not defensive, not aggressive, prepared. And as the judge announced a brief recess to review the submitted material, he realized something that made his stomach drop even further. This wasn't the reveal. This was still the setup. The recess lasted 15 minutes. He spent them staring at the polished surface of the counsel table, jaw clenched, replaying every exchange in his head like a security feed he could rewind and control. Across the room, she sat alone, exactly where she'd been before, hands resting on the folder, posture unchanged. No phone, no pacing, no whispered conversations. She wasn't nervous. His lawyer leaned in close, voice low and urgent. You didn't tell me about those secondary accounts. They weren't relevant, he snapped back just as quietly. They're relevant now, the lawyer said, and the judge knows she's not improvising. He scoffed. She doesn't even have counsel. That may be strategic, the lawyer replied. Judges give latitude to pro se litigants, especially organized ones. Organized, again. When the judge returned, the room snapped back to attention. The murmur died instantly. Papers were straightened, chairs adjusted. He felt his pulse in his throat. "Let's continue," the judge said. He didn't start with him this time. "Mrs. Carter," the judge said, "you requested additional permissions in your initial filing. Would you like to address those now?" "Yes, Your Honor." She stood. This time, the movement felt heavier, finaler. She took one step forward, then stopped, as if grounding herself before speaking. "I'm requesting the court admit supplemental material," she said, "including communication records and third-party statements relevant to asset concealment and decision-making authority during the marriage." His lawyer was on his feet immediately. "Objection! Scope!" The judge didn't even look at him. On what basis? These materials weren't disclosed during discovery. They were requested, she said calmly, and delayed. The judge turned to the clerk. "Were these requests logged?" "Yes, Your Honor." "Then overruled." The word hit like a dropped gavel. She handed over another set of documents. This time, he recognized them. Email headers, bank notifications, time-stamped messages. His chest tightened. The judge scanned the first page, then the second. "Mr. Carter," he said evenly, "these communications indicate unilateral financial decisions made without spousal knowledge. Is that accurate?" He opened his mouth, then closed it. "They were administrative. Someone had to handle things." "And yet," the judge continued, "these messages instruct institutions to withhold information from Mrs. Carter." Silence. The kind that presses on the ears. His lawyer leaned in again, panic barely masked. "We need to object, now." "On what?" he hissed back. The judge turned to her again. "Mrs. Carter, you may proceed." She didn't rush. She didn't dramatize. "For years," she said, "I was told I didn't need access, that it was simpler if one person handled things. I believed that. I trusted it. Until the information stopped matching reality. She wasn't emotional, but something in the room shifted anyway. Everything I've submitted," she continued, "comes from records generated without my involvement. I didn't create them. I didn't alter them. I only requested them." The judge nodded slowly. Then he looked directly at him. "Mr. Carter, did you believe your wife would never ask?" The question wasn't accusatory. It was diagnostic. He swallowed. "I didn't think it was necessary." The judge's gaze held. "Or did you think she wouldn't know how?" That was when it happened. The smirk, the one he'd worn that morning without realizing it, finally vanished because for the first time he understood what this really was. She hadn't come alone because she was weak. She came alone because she didn't need anyone to speak for her. The judge leaned back in his chair and removed his glasses. That small gesture did more to unsettle him than any raised voice could have. "Mrs. Carter," the judge said, "you indicated third-party statements. I'd like to review those." "Yes, Your Honor." She stepped forward again, placing a final set of documents into the clerk's hands. Thicker this time. He caught a glimpse of letterheads as they passed. Institutional, professional. Not friends, not family. People with credentials. The judge read silently. Seconds stretched, then minutes. His lawyer shifted beside him, fingers tapping once against the table before stopping. The sound felt too loud. He tried to steady his breathing, telling himself this was still manageable. Financial disputes could be negotiated. Numbers could be reframed. Intent could be softened. Then the judge spoke. "These statements include sworn declarations from a forensic accountant, a compliance officer, and a former advisor of yours, Mr. Carter." His head snapped up. "Former advisor?" The judge looked at him over the rim of his glasses. "Yes." His lawyer whispered. "You said that relationship ended amicably." "It did," he muttered. "Years ago." The judge continued, voice even. "According to this testimony, assets were intentionally restructured following marital disputes, specifically to limit visibility and future division. That's not—" He stopped himself, throat dry. The judge raised a hand. "I haven't finished." He felt every eye in the room turn toward him. Clerks, observers, even people waiting for other cases. This was no longer private. This was becoming instructive. "Mrs. Carter," the judge said. Did you instruct any of these parties on what to say? No, Your Honor. Did you request that they frame their statements in a specific way? No. Did you offer compensation? No. The judge nodded slowly. Then their testimony stands on its own merit. His lawyer stood abruptly. Your Honor, this is turning into a character trial. The judge's response was immediate. No, this is turning into a pattern analysis. That word again. Pattern. The judge turned to him. Mr. Carter, you've described your actions as administrative, yet these documents suggest forethought, timing, coordination. Do you deny that? He felt the room closing in. I was protecting myself, he said finally. That's not illegal. The judge tilted his head. Protection implies threat. Who were you protecting yourself from? He didn't answer, because the truth sounded worse when spoken out loud. The judge exhaled slowly. This court doesn't punish preparation, he said, but it does examine concealment. He glanced at Mrs. Carter. You may continue. She stood again, but this time there was no paper in her hands. I won't, she said. The room stilled. I've submitted everything I intended to, she continued. I don't need to add anything. That unsettled him more than another document would have. She wasn't pushing. She was done. The judge studied her for a long moment, then turned back to the file. Very well. He closed it. The sound echoed. I'll be frank, the judge said, looking directly at him. This case no longer presents as a standard dissolution. It presents as a matter of imbalance. His lawyer started to speak. The judge cut him off with a glance. Mrs. Carter entered this courtroom alone, not unprepared, not confused, but informed. He felt something break then, not loudly, not dramatically, just enough to let fear through. The judge leaned forward. This court will not issue a ruling today. His lawyer let out a breath. Relief flickered. Instead, the judge said, I'm ordering a full review. The relief died instantly. Independent forensic audit, temporary financial injunction, revised disclosures under oath. His lawyer whispered, This is bad. The judge's eyes never left him. Mr. Carter, I suggest you take this process seriously. Because now the judge wasn't listening to arguments. He was watching behavior. And across the room, his wife sat quietly, hands folded, eyes forward. She hadn't raised her voice once. She hadn't attacked. She hadn't needed to. She had let him speak, and the court had heard enough. The courtroom didn't empty the way it usually did after an adjournment. People lingered, whispered, watched. He felt it as he stood, the shift in how others looked at him now. Not curiosity, assessment, like a calculation being redone with new variables. His lawyer gathered papers too carefully, movement stiff, avoiding eye contact. This isn't over, the lawyer said under his breath, but you're exposed. He strained his jacket. She got lucky. The words sounded hollow even to him. Across the room, she was already packing up, still alone, still unhurried. When she turned to leave, the judge spoke again. Mrs. Carter, she stopped. Yes, Your Honor. I want to be clear, the judge said. The audit process can be invasive, time-consuming. You understand that? Yes. And you're prepared for what it may uncover. She nodded once. I am. The judge studied her for a beat longer, then nodded back. Very well. That was it. No warning, no advice. Just confirmation. They exited separately. He watched her walk down the corridor ahead of him, back straight, steps measured. No shaking hands, no breakdown. The image irritated him more than anger would have. Outside, his lawyer finally stopped. We need to get ahead of this. How? He snapped. By explaining, by cooperating. He laughed sharply. You don't cooperate your way out of accusations. These aren't accusations anymore. They're findings and progress. That phrase stuck with him. Findings. In the days that followed, the process moved fast. Banks froze accounts, notices arrived, requests for clarification multiplied. The forensic auditor's name appeared on official letterhead. Someone thorough, expensive, relentless. Old advisors stopped returning calls. One resigned outright. At night, he lay awake scrolling through emails he'd once dismissed, rereading messages from her he'd answered with half-truths and deflections. He searched for reassurance in familiar patterns, but they no longer worked. She, meanwhile, said nothing. No texts, no calls, no social posts. Not even through mutual friends. It was as if she'd stepped out of his orbit entirely. That silence unnerved him more than confrontation ever had. When the audit interview finally came, he sat across from strangers who didn't care about his explanations. They asked for numbers, timelines, reasons. Each answer triggered another question. Days later, a supplemental report landed on the judge's desk. Then came the summons, back to court. This time, the room felt different from the moment he entered, quieter, heavier. The judge already had the file open. She was there again, alone again. But now, no one mistook that for weakness. The judge didn't waste time. "Mr. Carter," he said, "the audit confirms deliberate concealment of marital assets." His lawyer started to speak. The judge stopped him. "It also confirms intent." That word landed like a sentence. The judge turned to her. "Mrs. Carter, you were patient, thorough, and restrained. This court recognizes that." Then he looked back at him. "And it also recognizes when one party believes control will protect them from consequence." His stomach dropped. The judge straightened the file. "We'll proceed to ruling."
No one moved when the judge said it. Not him, not his lawyer, not the clerk. Even the faint background noise of the building seemed to fade, as if the room itself understood that this was the point of no return. The judge didn't read from a script. He spoke slowly, deliberately, like someone who wanted every word to land exactly where it belonged. "This court has reviewed the forensic audit in full," he said. "It confirms a sustained pattern of financial manipulation designed to limit spousal access, visibility, and equitable distribution." He felt his lawyer tense beside him. "The concealment was not incidental," the judge continued. "It was strategic." The word echoed. Strategic. "For that reason," the judge said, "this court rejects the proposed settlement in its entirety." His breath caught. "Assets previously omitted will be reclassified as marital property," the judge went on, "including those held in secondary and tertiary accounts, investment vehicles, and trusts established during the marriage." His lawyer finally spoke, voice tight. "Your Honor, that represents a significant deviation." "It represents correction," the judge replied without looking at him. The judge turned the page. "Furthermore, this court finds that Mr. Carter exercised unilateral control in a manner that materially disadvantaged the other party." The judge's gaze lifted and locked onto him. "Which means the standard presumption of equal division no longer applies." The room felt smaller, closer, like the walls had leaned in. Across the aisle she stood when addressed, calm as ever. "Mrs. Carter," the judge said, "you requested no punitive damages." "Yes, Your Honor." "Despite having grounds." "Yes." The judge nodded once. "That restraint has been noted." He didn't look at her again. He looked at him. "This court orders a reallocation." The words came clean and final. "A majority share of disclosed and undisclosed marital assets will be awarded to Mrs. Carter." His lawyer whispered something sharp and urgent. He didn't hear it. "Additionally, this court refers findings of financial misconduct to the appropriate regulatory bodies for review." That was when it hit him. This wasn't just divorce. This was exposure. The judge closed the file. "Mr. Carter," he said, "you entered this courtroom believing confidence would carry you through. Instead, it revealed you." Silence. The judge went on. "You are not being punished for intelligence. You are being corrected for arrogance." He felt heat rise to his face, but there was nowhere to put it. No argument left that didn't sound like an excuse. The judge turned to her one last time. "Mrs. Carter, judgment will be entered accordingly." She nodded, just once. No smile, no reaction, as if the outcome had already happened months ago. The gavel struck. Once. And with that sound, everything he thought he controlled was gone. He didn't remember standing up. One moment he was sitting, staring at the closed file in the judge's hands.
And the next, he was on his feet, papers slipping from his grasp and scattering across the floor. No one rushed to help him gather them. No one needed to. The case was over. In the hallway outside the courtroom, voices blurred together. Lawyers discussing next steps, clerks calling the next docket, footsteps echoing against marble. All of it continued as if nothing monumental had just happened, as if his life hadn't just been reclassified. His lawyer spoke, but the words barely registered. Appeals, timelines, damage control. He nodded automatically, knowing even as he did that none of it would restore what he'd lost. Not the money, the illusion. At the far end of the corridor, she stood near the exit, waiting for the elevator. Still alone, still composed. The same woman he had smirked at that morning, convinced she was walking into defeat. She hadn't looked back once. The elevator doors opened. She stepped inside. Just before they closed, she finally turned her head. Their eyes met. There was no triumph in her expression, no satisfaction, not even relief, just calm certainty. The kind that comes from knowing something is finished and doesn't need to be revisited. The door slid shut. That was the last moment he saw her as his wife. Weeks later, the consequences spread outward, exactly as the judge had warned. Accounts reassigned, properties transferred. Notifications from regulatory bodies arrived with clinical precision. Former colleagues stopped answering emails. Invitations quietly disappeared. People didn't confront him. They adjusted. And that, he learned, was worse. Late one night, alone in an apartment that no longer felt temporary but diminished, he replayed the memory that wouldn't leave him alone. Not the ruling, not the audit, not even the referrals. The smirk. The one he wore when she walked into court alone. It had lasted less than a second, but it cost him everything.